I have sat on this bench for 38 years, and in that time, I have developed a fairly accurate sense of how long it takes for arrogance to cost someone something. Usually it takes a while, a few exchanges, a few warnings ignored, a slow accumulation of bad decisions that finally come due all at once. But on the morning of June 19th, I watched a woman named Denise Pruitt manage it in exactly 30 seconds, from her own mouth, in front of a full gallery, with no one forcing her to say a single word of it. I am going to tell you exactly how. Before I do, I want you to subscribe to this channel and turn on notifications, because we bring you stories like this one every single week. Stories from this bench about what happens when people walk into a room of consequence and decide to treat it like a performance instead. And drop a comment before we go any further. Tell me, have you ever watched someone be condescending to a person in a position of authority, fully convinced that nothing could come of it? Tell me what happened. Tell me whether they got away with it. Because Denise Pruitt did not. And the way she did not is, I think, one of the more instructive 30 seconds I have witnessed in nearly 4 decades of doing this work. Now, let us begin. The case before me was a small claims matter, the kind that fills most of my docket on any given Tuesday and rarely makes for dramatic television. Except that this one did, because of exactly 30 seconds of behavior from a woman who had clearly never once been told no by anyone with the actual authority to make it stick. The plaintiff was a 34-year-old contractor named Dario Esposito, who ran a small landscaping and home repair business with 2 employees, both of whom he had hired from the neighborhood where he grew up, both of whom he was, according to his own testimony, still paying in full during the months this dispute dragged on, out of his own pocket, because that is the kind of thing a small business owner does when a client refuses to pay and the bills do not stop arriving regardless. The defendant was Denise Pruitt, 52 years old, who had hired Dario's company to redo her backyard patio for a project totaling $6,200, and who had, according to the complaint, refused to pay the final invoice after the work was completed, claiming the work was substandard despite having approved every single stage of construction in writing via text message, copies of which Dario had submitted as evidence, time-stamped, unambiguous, and entirely consistent with the finished product she was now disputing. This is, on its surface, an unremarkable contract dispute. I see a dozen like it every month. What made this one different was not the underlying facts. The facts, frankly, were about as clean as small claims court ever produces. What made this one different was Denise Pruitt's approach to being in my courtroom, which I want to walk you through carefully, because the real lesson here is not really about a patio. It is about what happens when someone mistakes a courtroom for an audience and forgets in the process that the person sitting across from them is actually listening. Denise arrived on time, which I will give her credit for. She arrived without an attorney, having decided, she informed the court at the outset, that small claims court did not warrant the expense of legal representation, which is a perfectly reasonable position for a dispute of this size. What was less reasonable was the tone she adopted within roughly the first 90 seconds of the hearing, a tone that told me, before a single substantive word had been exchanged, exactly what kind of morning this was going to be. I called the case. I asked Dario to present his claim. He did so, clearly and without unnecessary embellishment. The original signed contract, the text message approvals documented at each phase of construction, photographs of the completed patio from multiple angles, and the unpaid invoice itemized in full. There was very little ambiguity in the record. I turned to Denise Pruitt and asked if she wished to respond to the claim. She said, "Well, I just think it's kind of funny that we're even here. This is what small claims court is for? A patio?" I said, "Mrs. Pruitt, this court handles disputes of all sizes, and a $6,200 contract dispute falls well within our jurisdiction. Do you wish to respond to the specific claim before us?" She said with a small laugh directed, I noted, more toward the gallery than toward me, "I mean, sure, Your Honor, if you want to take this seriously." I said, I do take it seriously. I would ask that you extend the same courtesy. She said, I'm sorry. It's just, I watch a lot of these court shows, and I figured this would be a little more, I don't know, exciting? No offense. I want to be clear about something here, because I think it matters for understanding everything that followed. I was not offended by the comment about court shows. I have heard considerably worse in 38 years. What I noted instead was the pattern beneath the comment. A person who had walked into a serious legal proceeding, having already decided before she ever sat down that nothing happening in this room could meaningfully touch her life, and who intended to spend her allotted time performing that belief rather than actually participating in the resolution of a real dispute involving a real working man's unpaid invoice. I said, Mrs. Pruitt, I would like you to respond to the specific claim before this court. Mr. Esposito has submitted text messages documenting your approval at each phase of the work as it was completed. Do you dispute the authenticity of those messages? She said, no, I sent those. I just changed my mind after I saw the final result. It wasn't what I had pictured in my head. I said, did you communicate that dissatisfaction to Mr. Esposito at any point during the project or upon its completion prior to the final invoice becoming due? She said, I mean, not really, but shouldn't he have just known? He's the professional. Isn't that literally his job, to know what I wanted without me having to spell it out? I said, Mrs. Pruitt, a contractor cannot reasonably be expected to intuit dissatisfaction that was never communicated, particularly when every phase of construction received your explicit written approval in real time as the work progressed with photographs attached. And then she said the thing. I want you to remember this moment specifically, because it is the exact instant where everything that followed became possible. And she said it with a small laugh and a glance toward the gallery, as if checking whether anyone was appreciating what she clearly believed was a clever observation. She said, with respect, Your Honor, isn't that kind of your job to figure out? I thought that's what we pay judges for, to use common sense instead of just reading documents at us all day. The gallery made a small sound, not a gasp exactly. The specific sound a room makes when it recognizes collectively and almost instantly that someone has just made a mistake they do not yet understand they have made. I said, Mrs. Pruitt, I want to make sure I understand precisely what you just said. You are suggesting that this court should disregard the documented evidentiary record of your written approvals and instead rule based on what you are describing as common sense, which in this particular case appears to mean your unilateral, undocumented dissatisfaction communicated to no one at any point until after the work was fully complete and the final invoice had become due. She said, I mean, when you put it that way, it sounds bad. But yeah, basically, that's kind of what I'm saying. I said, Mrs. Pruitt, do you understand that you are currently standing in a court of law and that the documents Mr. Esposito has submitted constitute the actual legal record of this transaction between you? She said, sure, but everyone knows you can talk your way around documents if you're clever enough about it. That's like half of what lawyers do for a living, right? Talk their way around paperwork. This is the 30-second window I mentioned at the beginning. I want to walk you through exactly what happened inside it, because it happened quickly, and I want you to understand precisely why it happened the way it did. I said, Mrs. Pruitt, this court does not operate on cleverness. It operates on evidence and on the law as written. You have just told this court, on the record, in front of a full gallery, that you believe the legal process can be circumvented through rhetorical performance rather than through facts. I want to address that directly because it has become directly relevant to my ruling. And then I am going to address something else that has become relevant in just the last 90 seconds of this hearing. She said, okay, I said, first, the underlying contract claim. Mr. Esposito has provided this court with a complete and entirely uncontested record of work performed and approved at every single stage. You have offered no evidence whatsoever disputing the actual quality of the finished work beyond your own unsupported and previously uncommunicated dissatisfaction. I find in favor of the plaintiff for the full amount of the unpaid invoice, $6,200. She said, "Fine, whatever. I figured that's basically what would happen anyway." I said, "I am not finished, Mrs. Pruitt." I said, "This court possesses the authority under the rules governing this jurisdiction to award additional damages when a party's conduct during litigation is found to constitute bad faith, including the pursuit or defense of a claim with no good faith basis, undertaken for purposes of delay, harassment, or simple disregard for the actual process rather than genuine, substantive dispute." You have just told this court, entirely voluntarily and on the open record, that you withheld payment despite having no documented basis for dissatisfaction at the time it would have mattered, that you believe legal proceedings can be circumvented through cleverness rather than facts, and that you did not regard the seriousness of this proceeding as sufficient reason to refrain from saying any of that out loud in this room today. She said, "Wait, what does that actually mean? What are you saying right now?" I said, "It means that your own testimony has supplied this court with the basis for a bad faith finding that I would not otherwise have had sufficient grounds to make on the record before us. I am awarding Mr. Esposito an additional $9,300 in bad faith damages and litigation costs, on top of the original $6,200 already owed. That brings the total judgment against you, as of this moment, to $15,500. The courtroom went very quiet. Denise Pruitt's expression in that exact second is something I have thought about more than almost any other moment in a small claims matter in recent memory, because it was the precise instant a person who had walked into a room assuming it could not meaningfully affect her realized in real time, watching it happen, that it just had, and that she herself had supplied every piece of the rope. She said, "Wait, you can't just do that because I said something you didn't like." I said, "Mrs. Pruitt, I did not do this because I personally disliked what you said. I did this because what you said constituted in this court's legal judgment a clear admission of bad faith litigation conduct, which carries a specific and entirely lawful remedy under the rules governing this proceeding. You are welcome to appeal this judgment through the appropriate channels, but I would encourage you going forward to treat every room you enter as though the people inside it are fully capable of holding you to exactly what you say in it. Today, in this particular room, that is precisely what happened." She did not respond. There was, for the first time since she had walked through those doors 90 seconds into this hearing, genuinely nothing left she wanted to say. I called a brief recess. When we resumed for the next case on the docket, I noted that Denise Pruitt remained in the gallery for several minutes afterward, sitting very still, looking down at the paperwork the clerk had handed her, before she finally stood and left the courtroom without another word to anyone. I do not know what happened to Denise Pruitt after that particular morning. Small claims matters rarely generate the kind of long-term follow-up that larger felony cases sometimes do. What I have in this instance is 30 seconds of transcript and a judgment for $15,500. And I have come to believe that this, in its own compact way, is a complete story regardless. Here is what I want you to take from it. Most consequences in life arrive slowly, accumulated gradually over years of small decisions that eventually come due all at once. But every so often, consequence arrives all at once, compressed into 30 seconds, because someone walked into a room they should have respected and decided instead, almost reflexively, to perform contempt for it in front of an audience they assumed was on their side. Denise Pruitt did not lose $15,500 because of a patio. She lost it because she stood in front of a person with the actual legal authority to make her own words matter against her, and she said out loud in a recorded proceeding exactly what she believed the entire process was worth. The law disagreed loudly in the only language that ultimately mattered to her. The bottom line of an invoice she will now spend considerably more time paying than the original $6,200 ever would have required. If you believe that respect for process is not optional, that courtrooms are not stages built for performance, and that the things you say out loud in a room of genuine consequence will eventually be measured against you whether you intended them to be or not, hit that like button right now. Subscribe to this channel because we bring you stories exactly like this one every single week. And leave a comment below right now. Tell me, have you ever personally watched someone talk their way into a dramatically worse outcome than the one they originally walked in with? Justice does not always arrive slowly, accumulated over years. Sometimes it arrives in exactly 30 seconds. And it arrives because you handed it every single word it needed, yourself, standing in the very room built to listen. Choose your words wisely. Every single time you stand in front of someone whose job is to listen, choose wisely. Project Content Courtroom Judge Canalo, created by YouTube Policy.txt101. Linus text Cook is then en videolaren transcripte der basliklere.txt18. Linus text. Content. I have seen a lot in my 40 years on this bench. I have watched the rich walk in like they own the room. I have watched the powerful try to use their title as a shield. But what walked into my courtroom on the morning of November 14th at exactly 10:30 a.m. was something I had never seen before. A 32 pasted